Hi everyone, welcome back to Kampusoasis Law Tutorials. I remain your instructor, Ile Mobayo Abuiwa. This is our drafting class on deeds, and in this video, I'm going to help you understand the meaning of a deed. So if this is your first time of hearing about this legal document, you'd be able to relate with it and it will not sound abstract. In the subsequent videos attached to this playlist, we will then talk about the various parts and clauses of a deed, and to be more specific, a deed of assignment. So please ensure that you pay attention to the do's and don'ts that I'll be sharing during the course of my explanation. So let us begin with the first question. What is a deed? A deed is a legal document with a fixed drafting structure that must be signed, sealed, and delivered by the parties involved in any transaction where the law requires it. A deed is usually used to effect the following purposes. 1. To transfer an interest in property. To extinguish an obligation or interest in property. 3. To delegate or revoke a power earlier conferred on another. 4. To rectify an error in an existing deed. And finally, to confirm an already conveyed right or interest in property. In order for us to be able to appreciate this definition of a deed, we'll take a look at it from 4 perspectives. 1 is the meaning of a definition of a deed as to relevance, that is applicability. The meaning of a deed as to purpose. The meaning of a deed as to validity. And the meaning of a deed as to structure. Now, let's discuss the meaning of a deed as to relevance, that is applicability. And for that, we would go down memory lane. In Module 1 of this course, we treated various property law transactions, such as sale of land, mortgage, lease, tenancies, and I also taught you how to identify these transactions in any scenario, no matter how it has been twisted, right? We also learned that these transactions ought to be reduced into writing, that is, ought to be evidenced. Whatever has transpired between parties ought to be reduced into writing. So as a legal practitioner, you will need to draft legal documents in respect of these property law transactions. But you and I know, and it is blindly obvious, that there are pretorias of legal documents. And you know them. We have contractual documents like tenancy, right? We have testamentary documents like wills, codicils. We have court processes, and all these are legal documents, right? And a deed, being a form of legal document, as we have seen in this definition, is actually tied to certain or to specific property law transactions. Which is why when you look at the definition, the phrase involved in any transaction where the law requires it, meaning that there are plethora of transactions, but a deed, being a legal document, does not apply to all property law transactions and does not also apply to all forms of documents that exist under property law practice course. There are plethora of legal documents, just as we have mentioned. Not every legal document that is to evidence transactions between parties ought to be by way of deed. However, when these transactions are required to be evidenced by deed, as a legal practitioner, you must be able to identify these transactions. And in the main tutorial video, we listed transactions that ought to be by way of deed, documents that ought to be by way of deed, and the ones that the law does not require it to be by way of deed. So, a deed, therefore, is a legal document that you as a legal practitioner prepare for your client to evidence whatever has transpired between them in context now for property law transactions where the law what requires it. So it's a question of law as to when to prepare a deed. Take note that because the law requires it, it means that whatever interest is involved in such a property law transaction will only be valid and enforceable in law where you prepare a deed as proof of evidence of such transaction. Now, for the sake of example, we'll use a sale of land transaction. In a sale of land transaction, the law requires that a deed of assignment must be prepared before you can say that legal interest has passed from assignor to the assignee. Now, parties cannot waive this requirement of law. Therefore, where a sale of land transaction has been purported to happen between two parties, party A being the assignor, party B being the assignee, and a deed of assignment was not prepared, because they have failed to comply with the requirements of law, you cannot say that legal interest in that land has passed from the assignor to the assignee. Therefore, a deed of assignment is the requirement of law before you can say that such a transaction has transpired between the parties, and before you can say that the interest sought to be transferred or conveyed to the other party has met the requirement of law. So that is deed as it relates to applicability. So you don't prepare deed for every property law practice transaction. It is not every document that must be by way of deed. When it should be by way of deed, it's a question of law. So, having said that, let's talk about deed as it relates to purpose. When we say deed as to purpose, we are actually referring to the functions of a deed. We already settled that a deed is not applicable to every property law transaction. But since we have been able to identify some of the transactions where it applies, we then want to talk about the functions of a deed in relation to those specific transactions. Just as we have nutrients, but there are specific examples of nutrients, such as carbohydrates, proteins, vitamins, minerals. And if I were to ask you, tell me the functions of nutrients, you will tell me that, oh, you need nutrient to have energy. But what you are really talking about is what? Carbohydrates. Nutrients are necessary so that we can build tissues. You are actually telling me about what? Proteins. So by mentioning these functions of a deed, we are actually trying to tie it to specific examples of a deed. So you don't have to memorize this. All you need to know is just know, okay, this is a transaction where deed applies. This is the legal document to be prepared. It's a deed of assignment. What is the function of a deed of assignment? It serves this function. You remember. What is a mortgage? This is the definition of mortgage. This is a document to evidence mortgage. What is this document trying to do? That is the function. So you don't have to memorize this at all. So let's begin with the first one, which is that it is to transfer an interest in property. By interest, we are referring to legal interest in property. There are many interests that exist in property. You have the possessory, you have easements, so many things like we mentioned in module 1. You have the equitable interest. But when talking about deed, our focus is on the legal interest that exists in property. So the use of a deed is that is how you effectively transfer legal interest from party A to party B. So where any property law transaction requires that party A transfers legal interest to party B, the legal instrument that must be prepared in relation to that transaction must be by way of deed. And an example of such transaction is a sale of land transaction, where a deed of assignment is prepared in order to transfer legal interest in that land to the assignee. Another example is a mortgage transaction, by way of legal mortgage, right? Where the mortgagor wants to secure loan, right, from the mortgagee, or wants to guarantee that he will carry out an obligation, and he intends to use his legal interest in land to secure that loan. The legal instrument he must use to transfer that legal interest to the mortgagee is a deed of legal mortgage. So a deed of legal mortgage will serve the purpose of transferring that interest in property to the mortgagee. A deed of assignment will serve that purpose of transferring that interest in land to the assignee. When you talk about gift intervivors and a deed of gift have been prepared, the donor is able to transfer total ownership to the donee, right, in that gift intervivors. Therefore, a deed is used to transfer interest in property. So you can see how, because I know the examples of a deed, I'm able to bring out the functions of a deed. Secondly, we have the functions of a deed, which is to extinguish an obligation, that is to extinguish an interest in property. To extinguish an interest in property, to bring that interest to an end, such that if for any reason I give you my legal interest, now I want to get it back, right? Whatever we have agreed now ends. And an example that readily comes to mind is the mortgage transaction, right? And you know, under mortgage, what is taking place is that the mortgagor needs money, right? But the mortgagee has the money. Whereas the mortgagor does not have money, he has properties and he has legal interest in that property. He then wants to use that legal interest in property to secure loan from the mortgagee. But the purpose of involving himself in that transaction is not to sell his land to the mortgagee. The purpose is just to say, I will pay you back your money, but for this period of years, take my legal interest. When I repay back the loan, then you transfer back. This my legal interest will revert back to me. So one of the functions of a deed in that transaction is that when you prepare the deed of legal mortgage, you give him your legal interest. When you have finally repaid back your loan, one of the deeds that should be prepared, or an example of deed that can be prepared, is a deed of reconveyance. A deed of reconveyance. Of course, there are many deeds to prepare, different kinds of deeds. You can prepare if you want to extinguish that interest. For example, you have the deed of discharge, there's deed of release. What all these examples of a deed serve is that that is what you prepare if you want to extinguish an obligation or interest in what property. So in relation to mortgage transaction now, where a deed of release, a deed of discharge, what you are saying is this mortgagor has fully paid back his loan. I have returned back his legal interest, has reverted back to him. So that deed of release, deed of reconveyance, deed of discharge has serves the purpose of extinguishing that obligation or interest in property that you transferred to the mortgagee. The next function is that a deed serves the function of, you can use a deed to delegate or revoke a power earlier conferred on another. Why did we separate point 2 from point 3? The reason is that point 3, of course, you already know that it talks about donation of power, right? Or power of attorney. Now, where a power of attorney has been created by way of deed, the purpose of creating that power of attorney is so that you can delegate your power to the donee. So once that power of attorney is prepared by way of deed, that it is made under seal, the donee can then act on your behalf. Also, you are not stopped from revoking such powers. Of course, please watch the video, the drafting video on power of attorney, so that you can know where exactly the donor may revoke the powers and instances where it cannot unilaterally revoke such powers. We also discuss this copiously in our main tutorial video. So it can use that power of attorney made by way of deed to delegate power to the donee. Also, where since he has donated that power by way of deed, he can only revoke that power by deed. And one The example of a deed that can be prepared in respect of this revocation is known as a deed of revocation. So I can prepare a deed of revocation to revoke the power that I've what granted to the donee. So the donor cannot say the donee has gotten me angry. I don't need you to act as my donee again. No. Once you have made it by way of deed, you can only revoke it by way of deed because that is what the law requires. That is what the law requires. The next function is that a deed can serve the purpose of rectifying an error in an existing deed. You must agree with me that we are humans, and sometimes there can arise factual mistakes or clerical error in the process of preparing a document. And you know that it is possible that since a deed needs to go through certain level of perfection, like obtaining governor consent, stamping and registration, you might have gone through all those perfection stage and then later realize that, oh, there's an error in this document. Or maybe the information that was supplied to you, they did not give you the accurate information. Let's say in the sale of land transaction now, where a deed of assignment has been prepared, the description of the property. You now realize that in the survey plan, they said the land was 6 by 5 square meters, right? But later they down to that, no, 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 no. It's 7 by 5. But don't forget, you have gone to obtain governor's consent, you have gone through all the process. How then do you correct the error in that deed? It's not by saying bring black pen. It's not by saying yeah, bring black barrel, let's just change it from 6 to 7. No, what you have to do is to prepare what is known as a deed of rectification so that you can modify the existing deed of assignment to reflect the correct fact surrounding the transaction. And of course, another name, and please take note of this for the purpose of your MCQ, another name for deed of rectification is a supplementary deed. So they might not tell you deed of rectification. They just tell you, you just see the option supplementary deed. And let me even give this one free of charge. Let's say that you have a scenario where it's clearly obvious that from the questions they've been asking you, there has been an error, and then they ask you, what would you do? What will you do? Let's say that the scenario said the name of the parties is Mr. A and Mr. B. Then you now realize that after preparing the document, you wrote Mr. C. You are now asked, what will you do in order to? The answer is very simple. You will need to prepare what? A deed of revocation or a supplementary deed so that you can modify the error in that existing deed. Also, the last function is that it can be used to confirm an already conveyed right or interest. And here, this is just very simple and straightforward in the sense that you know that there's no hard and fast rule to this. It's possible for somebody to have an interest in a land, and because the person is very rich, right? The discussion on buying the land, right, it will not last more than 5 minutes. The person will just ask that, okay, is that land good? Yes. Um, the papers are they complete? Yes. What's your root of title? We have deed of assignment. We have deed of gift. We can give you abstract of epitome of title to prove it. And like, okay, you know what? How much is the money? What's the consideration? 50 million. Okay, just send your account number. Let me pay. Now, just in 5 minutes, that sale of land transaction in quotes has taken place. Right now, all you need to do is what you can later go ahead and what prepare the deed of assignment. So that's why it's just used to confirm an already conveyed right or interest in property. So this is deed as it relates to the function. So notice that each of these functions are tied to the examples of a deed used in those transactions where the law requires it. Now, the third one is deed as to validity. Deed as to validity. And you know that anything relating to validity goes to the root of enforceability. Once an act or a document is not valid, then you can't bring up anything as related to enforcement. The law will not enforce an illegal transaction. The law will not enforce a transaction or a document that has not complied with the strict requirements of law. So, as to validity of this legal document known as a deed, let me read the definition once again. In our definition, we learned that a deed is a legal document with a fixed drafting structure that must be that must be signed, sealed, and delivered by the parties involved in any transaction where the law requires it. So notice that phrase now, must be signed, sealed, and delivered. Notice is a must. So when you talk about these legal documents, that is all these examples of deeds we have mentioned, deed of assignment, deed of rectification, supplementary deed of revocation, deed of release, deed of reconveyance, deed of legal mortgage, lease, for that document to be valid, for you to even say, this is a deed, though, it must have been signed, sealed, and delivered by the parties. So parties cannot waive this fundamental requirement for validity. So even if you don't understand what it means to sign it, even if you don't understand what it means to seal it, even if you don't understand what it means that a deed was delivered, at least you can remember. If somebody should wake you up tomorrow now, a deed must be what? Must be signed, sealed, and delivered. Now, why I'm saying this is because in the main tutorial video, we had explained all it means. In fact, we talked about the issue of signature, why the signature. We talked about it being sealed. We talked about what does it mean to be delivered. So even if we are not going to elaborate on those points, at least one of the takeaways you have from this video is that a deed has to be signed. At least you can relate with that. They have to append their signature, right? Has to be signed, has to be sealed, and has to be delivered before you can say that that legal document is a deed. What if it was not signed? What if it was not delivered? What if it was not sealed? Then what if it was not signed, sealed, and delivered? Then it goes to the root of what? Validity. And you cannot enforce that document. In fact, if it is not signed, sealed, and delivered, you can't say that you can carry out all these functions. In all these functions we have mentioned, you can't say that that particular deed will carry out that function if that deed of us, if that deed, right? For example, deed of assignment has not been signed, sealed, and delivered. Now we'll move to the next the next perspective, which is deed as it relates to what? Structure. But we're going to talk about that in the next video so that we can now use that as a template to now talk about the parts and clauses of a deed. So please ensure that you watch the next video. The video is attached to the playlist. The playlist is deeds. So when you click on the playlist, you are going to see this first video and the subsequent videos. And also, please, if you have not subscribed to the channel, please subscribe and also share with your friends, right? If you find this video helpful, please share it with your friends so that you guys can learn the same thing and be successful together in your bar finals examination. So please ensure you watch the next lecture video.